Hello friends, in the series on the income tax cases, today we will discuss the case of Director of Income Tax International Taxation versus Microsoft Regional Sales Pte Limited. This case has been reported in 454 ITR at page number 19. The matter has been decided by Supreme Court and the date of the judgment is 29th March 2023. This case is related to section 9, which says about income deemed to accrue or arise in India, and this case relates to the assessment year 99, 2000 to 2001, 2002. In this case, a very limited issue was before the Honorable Supreme Court. In this case, the assessee was a non-resident company. During the previous year relevant to the assessment year, the assessee sold software to the Indian customers and distributors. When the assessment was going on, the learned assessing officer was of the view that the sale to the Indian customers and distributors of the software is royalty, and accordingly he imposed the tax on the assessee. When this matter was before the ITAT gave relief to the assessee and held that sale of software by a non-resident company to the Indian customers and the distributors is not a royalty, which was confirmed by the High Court. And while confirming the order of the ITAT, the Honorable Delhi High Court relied upon the judgment of the Supreme Court, Engineering Analysis Centre of Excellence Pvt Limited versus CIT, which was reported in 432 ITR at page number 471. Meaning thereby that Delhi High Court, relying upon the judgment of the Supreme Court, upheld the order of the ITAT in favor of the assessee. The department moved to the Supreme Court, that is, the department filed the special leave petition against the order of the Delhi High Court, and the Supreme Court also dismissed the special leave petition of the department, but gave a rider in the order that if the review petition which was filed by the department in the case of Engineering Analysis Centre of Excellence Limited versus CIT is allowed by the Supreme Court, then the department in the present case will be allowed to file the review petition before the Supreme Court. Although this matter has attained more or less the finality because the order of the Supreme Court is the order of the law of land, or you can say that whatever has been decided by the Supreme Court is the law of the land, but because the department has been given the liberty to file the review petition, if the Supreme Court allows the review petition in the case of Engineering Analysis Centre of Excellence Pvt Limited versus CIT, then it means that there is still the chances that the Supreme Court can allow the special leave petition in that case. So the matter is still open, but in this case, for the time being, the special leave petition of the department in the present case was not admitted by the Supreme Court. Friends, with due regard to the Supreme Court, when these matters come, then there should be some procedure like that if these matters should be decided only when the review petition on the same matter is being decided by the Supreme Court, because otherwise it will lengthen the procedure of appeals for the assessee, because sometimes it happens that a number of the special leave petitions are dismissed and after that the review petition of the department is allowed, then all those cases which have been decided in favor of the assessee will get again revived. So the process of litigation becomes a lengthy process. At the end of this video, once again I am repeating the name of the case. The name of the case is Director of Income Tax International Taxation versus Microsoft Regional Sales Pte Limited, and this case has been reported in 454 ITR at page number 19. The matter has been decided by Supreme Court and the date of the judgment is 29th March 2023. Thank you friends.